understand it. And I had a t-shirt, and I wish I brought it. It says, "You have the right to remain silent. If you give up that right, anything you say will be misquoted and used against you in a court of law." That's my understanding of criminal law. That's why I tell my clients, don't say anything. Or if you need to say something, call your lawyer first. Do they listen? Nah. That's why we're in business. I wanted that t-shirt, but I couldn't find it, but I found this one, which I really like. Empty promises, calculated betrayal, sociopathic greed, just another Monday. Welcome to criminal law. Okay. I want to tell you a little bit about myself. Take a couple hours, but how I got here. Grew up in Massachusetts, lower middle class, and I wanted to get out of there. I was going to go to California, bright lights, Hollywood, the whole deal. Got to California, went to law school. Said, oh, this is great. You know, I'm going to be an entertainment lawyer. Moved to LA and figured out entertainment lawyers, all they do is write contracts. I don't want to write contracts. So figured out, gee, criminal lawyers, they go to court. This sounds like fun. So I kind of gravitated to that. Moved to Nevada. Started practicing criminal law. This was fun. In the good old days, before Rule 250, they'd appoint you to anything. I started practicing, moved here in '84, had my own practice. June 1, '86, was appointed to 2 murder cases in the space of 1 month. First murder case I was ever appointed to, wasn't the first one I tried, but the first one I was ever appointed to, went to the U.S. Supreme Court. David Riggins. He stabbed someone 32 times, broke off the knife in his head, thought that JFK was his father, Marilyn Monroe was his mother, and the mafia was trying to kill him because he bought stock in IBM. Turns out he didn't, but be that as it may. Went to trial, we lost. They medicated him against his will. Gave him 800 milligrams of Mellaril, which my expert says was enough Mellaril to medicate, to tranquilize an elephant. So went to trial, we lost. Went to Nevada Supreme Court, we lost. And when Judge Brennan, who's now a senior judge, ruled that couldn't take him off the medication, I went back to my office, said this case is going to go to the United States Supreme Court. And it did. I argued it, which they say it's very unusual that the trial lawyer argues it, but this was my baby. It was interesting because after they granted cert, I got a call from all these law firms. Oh, we'd like to assume the defense. I got a call from Williams and Connolly, Tripp somebody the third, his family's been practicing since the Mayflower. Oh, we'd like to assume the defense. Oh, you'd like to help me? No. We'd like to assume the defense. Oh, so after I busted my butt from the trial level up to here, filed the petition for certiorari and have his granted, you want to take over my case? I don't think so. So anyway, I did it. I won. I've retired from U.S. Supreme Court practice, so no one will ever have a better percentage than me. Anyway, it was interesting, but I thought that there were going to be a lot of newbies here. And obviously we have some graybeards, which is fine. I can talk to anyone, as most people well know that know me. Be that as it may. But what I wanted to do is kind of give you an overview of criminal practice as I understand it and how it goes. I'll go through some of the nuts and bolts. I do know that there's a couple of people that don't practice much criminal law, and for those who do, you'll have to bear with me. And for the last hour, I'm going to do my PowerPoint presentation using theater in the courtroom. Everyone will like that. Everyone usually likes that. So have to bear with me for the first hour for the nuts and bolts. Sorry there's no ethics, but you're lucky because usually when I speak, they take ethics hours away. So they promised me they wouldn't do that today. All right, where are we starting? Interesting about Miranda. Everyone that's not a lawyer knows about Miranda, but they don't really understand Miranda. People come up to me, well, You know, I have this friend, and they were arrested for this, and the cop didn't read him his Miranda right. You know, aren't they going to throw the case out? Well, tell me what happened. Well, they pulled him over, and when they pulled him over, they said, do you have anything? He said, oh yeah, well, I've got all this marijuana in the car. But they didn't read him his Miranda rights. I'm like, well, that's not quite the way it goes. But don't they have to throw it out? No. And then you need to educate them. Well, if they're in custody and they don't give you Miranda rights and you say something that was incriminating, then they can't use it. But they said something right then and there. It's like, well, was he really in custody? I mean, I'm not going to go through the ins and outs of being in custody, but you know what it is. But the question that most people get all the time is like, well, I was pulled over for DUI. They never read me my Miranda rights, then they gave me all these tests. They can't use them, can they? Well, yes, they can. Well, why? Because walking the line, holding your foot up, is not testimonial. So that's why they can use them. Now, sometimes in DUI cases, there will be times where they will ask you questions. I actually had a case in Reno where after they did the field sobriety test, the officer was NHP, and they actually have cameras, and it was recording, did not read my client his Miranda rights, and drove him for about an hour and questioned him the whole time. And he did make some incriminating statements because he didn't read him his Miranda rights. We suppressed that. We lost anyway, but at least we suppressed that. So yes, sometimes it does come into play. So I was going to talk about the practice of criminal law. And if you guys are practicing criminal law, a lot of people think we're like the low end of the totem pole. You know, just because we represent these awful people, that we're awful people. And you know, if you're practicing criminal law, you got to have thick skin. You know, because you got to let it roll off your back. And really, the only lawyers that are mentioned in the Constitution, we're the ones that uphold the Constitution. We're the ones that stand between the state and our clients. So don't ever let anyone make you feel bad. I applaud you for doing what you do. And everyone else should also. Now, when you start practicing criminal law, it's unfortunate in this state that we do not get a jury trial for misdemeanors. I started practicing in California, where you do. So you get one for DUIs, which is a separate breed of cat, and I'll talk about that later. But you get it for everything. Disorderly conduct, you get a jury trial. Domestic violence, you get a jury trial. Shoplifting, you get a jury trial. You don't hear, which, if you're in practice, in reality, is bad for the client but good for the lawyer, because you prepare a lot less for a judge trial than a jury trial. But for people that are starting out practicing criminal law, and I notice there's a couple of them, usually start with the easy stuff, the misdemeanors, petty larceny, battery, misdemeanor assault. Now, I've had clients say, well, what's your records? How many have you won? It's like, well, how do you decide? What's your criteria? Do you have to go to trial to win? Or if your client's looking at 20 years and you get him one, is that a win? Or in a petty larceny case, if you end up getting it dismissed and sealing the record, is that a win? I'd say it is. So on the lower level cases, you know, as I tell all my clients, and I've written all my notes, and I'll tell you right now, I can't follow a script, even if it's my own. But I think that that's also a strength in addition to a weakness, because you got to go with the flow. I think when people are up there and they're too wedded to their notes, they can't follow the flow, and in the courtroom, in a trial, you miss things, and you miss golden opportunities. And I don't think that's a good idea. And like right now, I'm not using the PowerPoint, I'm not doing anything, because I think it's important to relate to people. We have a few more people than a jury, but it's like talking to a jury. And it's important that you talk to everyone. You folks can hear me okay, right? I speak loud. And I've been told that I have to be careful with the jury because sometimes I invade their space. I've taken a lot of seminars. I mean, Franny Forsman, like 20 years ago, put me on the CLE committee of the State Bar because, as she said, I've taken more seminars than any mere mortal. And I would go to the NACDL, National Association of Criminal Defense Lawyers. If you folks are going to practice criminal law, join it. The other thing is the Nevada Attorneys for Criminal Justice, which is our local affiliate. I helped start it 20 years ago. The best thing about it, there's a listserv where you can ask people questions. Hey, has anyone seen this? Does anyone have a motion on this? Everyone's really helpful. There's also a brief bank where people have done it. Unfortunately, right now the website's not working, but I left the application out there. And the best thing, which hopefully you'll never need to use, there's a strike force. So if any judge is threatening you with contempt, or if you ever get a subpoena or anything like that, the NACJ will represent you for free. So that's my solicitation. I'm a member. I've been a member from the beginning. I'm on the board of directors. We can always use new people, and it's really in your best interest if you're going to practice criminal law, and the NACDL also. But moving right along. So you start off with the easy cases. Disorderly conduct. What is that? You get into a beef with your neighbor. Usually you can get these cases dismissed unless you're in municipal court, because in municipal court they only handle misdemeanors. So as far as they're concerned, domestic violence and DUIs are like capital murder. So they're a little more inflexible. Now, most of you people know, but for you new folks, I want to go into the differences. There's Justice Court. Las Vegas Justice Court is the lower court in the county. So what Justice Court is the misdemeanor courts. So if you have a misdemeanor, DUI, domestic violence, shoplifting, that's where it is. You have a trial there. If you have a felony, that's the first stop. So you have your arraignment there, first court date, and then the preliminary hearing. Preliminary hearing is a probable cause hearing, which means there's a hearing to decide whether there's enough evidence to, and it's a term of art, bind you over, where there's enough evidence to move it to the district court to have a trial. Now, the standard is really low. It's slight or marginal evidence, which is a scintilla of evidence. If the DA has charged you and the DA knows what he's doing, you're going to get bound over. I've done over 1,000 preliminary hearings, and only 3 were not bound over. And in one of them, in front of Judge Mosley, and luckily it was a self-defense case because he's bad on everything else, but he used to get in fights. So if you got into a fight, you had a shot. And in my case, there was an altercation at a gas station, and they were jawing back and forth, and apparently this other guy approached my client in a threatening manner. Unfortunately for him, my client was a Gold Gloves champion. And as he said, I only hit him with one flurry. It was like boom, 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 guy went down. And then the problem was, my client went over to help, and his brother was there, and he goes, stay away, and he picked him up from the middle, you know, and so his head was down and everything, and didn't breathe right, and he died. And went to prelim, got bound over, and we did a writ. Now, for those folks that don't practice, when you appeal from the preliminary hearing to the district court saying there's not enough evidence, which is usually an exercise in futility, it's called a writ of habeas corpus. Why? I don't know. It doesn't make sense, but that's what it's called. So we filed a writ. The state responded and went in front of Mosley, and he looks at it and says, I don't know if there's enough evidence. Well, let's continue this. Why don't you work it out? And I'm like, well, charged with murder, I'm happy to work it out. Talk to the District Attorney, what do you think? I don't think he meant it. What do you think about involuntary manslaughter? Involuntary manslaughter is 1 to 4. It's probationable. My client's good with it. I'm good with this. No. Okay, go back into court. Have you worked it out? No. I'm going to continue it again. Can't you work it out? Go back to the DA. Look, can't we work this out? No, not involuntary. I said, okay. Even though I think it's too much, what about voluntary? Voluntary manslaughter, 1 to 10, still probationable. What about a cap? No. All right, how about just voluntary manslaughter? Why don't we do this? I'll take my chances. I figure I'm in front of Mosley. He's into fights. I got a good shot at probation. My guy's never had a problem before. This is the right judge for that. No. Go back in front of Mosley. Have you worked it out? No. I'm going to continue it one more time. By this time, it's like, look, let's just roll the dice. Get in there and make our argument. He said, I don't see a crime being committed. He kicked it. It's like the one and only, well, actually, there was another time I actually won on this. And DA got greedy. You know, I was willing to deal it. What it should have dealt at really would have been involuntary manslaughter. I would have been happy. Client would have been happy. He would have gotten probation. But bulls get fat, bears get fat, pigs get slaughtered. By the way, when I go through the whole thing, anyone has a question, just ask it. Don't have to wait. If I'm going to get to it later, I'll tell you, but ask it. If there's something that I'm not talking about you want to ask it. I don't care. You know, if I don't know it, if I haven't dealt with it, I'd be very surprised. So ask away. I won't be offended. I actually like it when people ask questions, because otherwise I'm going to get too much dry mouth. So that was my preliminary hearing story. And the other way, when you're in justice court, there's a charging document which is called a complaint. Complaint is DA, cop goes to DA, oh, here's the facts, I think this is a crime. Whatever they think it is, DA looks at it, okay, this is what I think. Woman's working, and this is a case I had. I can explain just about any point with a case I've had, because I've had so many cases. Woman's accused of theft and embezzlement. She worked in a casino, and there was $5,000 missing. They had tapes. Now, they had a tape of her walking around. She has her little bib, and one of her jobs was making change. So they had her, they saw her with the bib, she made change, and then the money was missing. It came out that she wasn't the only one that did the change drawer. There was a couple other people. We played the tape. You know, Your Honor, could have been her, could have been someone else. There's not enough evidence. And it was in North Las Vegas, and they played the tape, and we had to continue the prelim because it just took a long time. And it was funny because my associate was doing it. Of course, you know, I'm hands-on. I'm like, ask this, ask that. And the DA, and I won't mention his name, we get along now, but we had our moments then. Well, whose case is this? Is Mr. Yampolsky going to do this hearing? I said, with all due respect, Your Honor, he's my employee. And if I want to do this hearing, yes, I will. So we were so busy, John, the judge said, hey, I don't have enough time. We're going to continue this, which was great because now we got the transcript. I had everything, prepared a really in-depth cross-examination. We argued it, and, you know, oh, it's prelim. It's going to get bound over, of course. Judge takes a break. She takes it back in there. Took about 2 hours. She says, you know, I reviewed this video 4 times. I don't see the evidence. I'm dismissing this. Client's happy. And by the way, all her friends from the casino came, even ones that were state's witnesses, and they were clapping because they liked her. And she didn't do this. So we're walking out. Everyone's happy. DA leans over to me and says, this isn't over. He indicts her. So that's the other way you can be charged. An indictment, go in front of the grand jury. And I always forget, I think, and you can do federal, state, I'll get into federal later, but I believe it's between 18 and 23 people. And a grand jury, yes. I hardly ever waive a preliminary hearing, but some people will do it in a sexual assault case. If they don't want to put the witness through it, maybe they're going to resolve the case later. I mean, if I thought, and I don't want to be crass, but if I thought the witness was going to die, then I would waive it if that's the only witness, because if there's no opportunity to cross-examine, then they can't put on grand jury testimony because there is no opportunity to cross-examine. And if there's no preliminary hearing, they can't put that on. And there's a difference of opinion, because some people that do sex crimes will waive the preliminary hearing, saying that, they don't want to give them an opportunity to practice or anything like that. But I disagree. One of the themes that I always hit, and I'll get into it when I do my PowerPoint presentation, is the truth never changes. So if they're lying, they're not going to be able to keep it straight. And if you're going to trial on a sexual assault case, your defense is either it wasn't you or it was consent. So if that's the case, they got to be lying about something. So that's why I would never waive the preliminary hearing, because they're going to tell one story in the police reports. And usually, in addition to the police reports, which the officer is going to take, there's going to be the transcript. Now they videotape them, which is really good, because sometimes you look at the transcript, it's like, oh, this looks bad. And then you get the video. And I had a case where the transcripts looked bad. When you saw the kid on the video, it's like, oh, there's no question. He's making this up. And I mean, it was so bad that the officer, when he was questioning him, put his head down on the desk. And I'll talk about that case later, because now it was a great case, then it wasn't so great. But be that as it may. So I generally do not waive the preliminary hearing. As I said, some people do. I don't. I want to pin that witness down. You have another question? Okay, and I know I'm supposed to repeat. So you're saying, in my experience, do I find that the DA will push for a tougher deal after the preliminary hearing? Yes, for the most part, the best deal you're going to get is before you go through the preliminary hearing. But if their case is weak, and you can show that their case is weak, it will get better. Now, sometimes their witnesses are bad, and they may not think they're bad, but if you're a good cross-examiner and you can show that their witnesses are bad, that deal will get better. But every DA will say, this is it, this is as good as it gets, it's not getting better. And some may mean it, and some may stick to it, but some may say, this does not look good, and it may get better. Each DA is different, and some of them will stick to their guns when they have a bad witness and lose. So, but I personally do not like to waive the preliminary hearing. We don't get depositions in criminal cases here. In Florida you do. I think in Vermont you do, which would be great, because all you have is the police report, and then you go through the whole thing. And for those people who've done trials, and I think most people have, there are a couple of people who's tried less than 5 cases. Raise your hands. Okay, so, you know, you've read everything. You've read the evidence code. You talk about impeachment. And one of the things that witnesses do, and as I said, I can't follow a script. This is something I'm going to hit later, but it did come up, is if you're not telling the truth, you're not going to be able to remember it. And what happens, and this happens with officers a lot, especially when they want to embellish. You know, they want to say, oh yeah, well, I saw that he had the pipe in his hand. That's really an important fact in a case, because it never surfaced before. It didn't surface in the first interview. It was never in his police report. And this is really an important fact you have to bring out to the jury. And there's a trial skills seminar that's going to be put on by the NACJ, which I would recommend, and it's kind of based on the National Criminal Defense College in Macon, Georgia, and I'll talk about that later, lest I forget, so remind me. But the whole thing is, they say that, a lot of lawyers say, well, there's your police report, and that wasn't in there, right? Right. And that's how it is. But you can't do that, because what you need to do, you have to show the jury that they didn't put that in there and it was important, so you have to build it up. And I'll do a quick short version. It's like, so, you're a police officer. Yes, you've been a police officer 10 years. Yes, and before you're a police officer, you were a cadet. Yes. And you became a cadet 6 months. Yes. And you're taught how to be a police officer. Yes. And you're taught how to write reports. Yes. And it's important you write reports. Yes. Because you rely on them. Yes. And the prosecutor relies on them. Yes. And it's very important because you have a lot of cases. Yes. And you don't remember every case. Yes. So you have to refresh your recollection of your report. Right. Yes. And after you write your report, if there's something missing, you could do a supplemental report. Yes. Or you could do an addendum. Yes. You could do all those things. Right. Yes. Okay. Now, in this case, you didn't write a supplemental report. No. Didn't do an addendum. No. Okay. Well, officer, and there's a couple ways to do it. Could you show me in here where it says that he was holding the pipe? Thank you. So you got to build it up, build it up, build it up, build it up. I don't know if you folks are familiar with Tony Serra. Great lawyer. He's out there. He's like a hippie. He's got long gray hair. He's up in San Francisco. He's got a medical marijuana card. His kids are named like Moonbeam and Sunshine and Rainbow. And apparently he has like one suit and it's falling apart. He doesn't wear underwear, but I digress. Anyway, I've heard him speak, and he's a magnetic speaker. He's unbelievable. And one thing he said, which I've never forgotten, he says, give me a kernel of moral truth and I will build a cathedral around it. Because let's face it, if you're going to trial, you got bad facts. Because if you don't have bad facts, you're dealing your case. So you got to take whatever you have and build it up. And lots of times the police will gild the lily, and you got to use that. Now you got to be careful because people want to trust the police. So you can't come out and say they're a lying sack of crap, even if you think so, unless it's really, really obvious. So they were mistaken. They forgot. But if they start putting in a lot of things, then you can call them on it. Now, where were we? Okay, so I'm going back to the charging documents. So we go back to the grand jury on the case with the indictment. Now, if a case is dismissed, when they go to the grand jury, the prosecutor has a duty to present any exculpatory evidence. So the fact that it wasn't bound over at preliminary hearing, that's certainly exculpatory evidence. And if there's other stuff and you have that you need, you want the grand jury presented, you write a letter to the prosecutor, and usually they'll present it. Sometimes they won't, then you file a motion to dismiss because they didn't. So in this particular case, I filed, I wrote the prosecutor a letter. It's like, please be sure to let the jury know, to let the grand jury know that this went in front of an impartial magistrate, blah, blah, blah. There was a 2-day hearing, and the judge dismissed it. So that was that. It was presented to the grand jury, and then you can also file a writ with the grand jury. Same thing like a preliminary hearing. You're appealing from the charge by the grand jury saying there's not enough evidence. And there's an old saying, I'm sure everyone's heard it, that a good prosecutor can indict a ham sandwich. There's no defense lawyer there. So I filed the writ, and the state opposed it, or the state asked for more time. So it's like, okay, fine, they want more time. And then they finally filed their response. And I filed my reply, and things are getting a little chippy. So, you know, things are ratcheting up. And when I was younger, I would put stuff in writing that, you know, I wouldn't do now. And, you know, there was something in there like, oh, they did it one day late for something. And it's like, you know, this is like, oh, my dog ate my homework. And, you know, keeping with the dog metaphor, that dog won't hunt. And so the judge gave him time to fix it, and we're in there. And this one particular DA, who's now a judge, who I won't mention by name, I saw him in the hallway, and he said, oh, Mace, I want to argue this. It's like, okay, fine. It was in front of Sally Lore. I don't know how many know her. She's retired. Great judge from Indiana. Talk like a sailor. And one of her favorite expressions was, don't tell the cow where the cabbage patch is. So we're in there, and it's like, well, Your Honor, you know, Mr. So-and-so says that he wants to, because she called the case, wants to argue this, so can we wait? She goes, no, this is what we're going to do. Miss DA, this was supposed to be filed by this day. It's one day late. Case dismissed. Oh, I like this. So we walk out. You know, I told D, I said, hey, I tried. You know, look at the transcript. So they appealed to the Nevada Supreme Court, and I won. I should have won. I mean, I felt bad for the client. I had to keep charging her more money, but I won. But, you know, sometimes that's what you got to do. And lots of times, unfortunately, clients don't have the money to keep fighting. And it's too bad, but that's just the way it is. That's why, in some ways, it's almost better to have appointed clients. Now, one thing, if you have an appointed client, I'll get into that later about the different levels of appointment. It's good because now we have this in state court, the Office of Appointed Counsel. So if you get appointed, then Drew Christensen, who used to be a PD, who's a good PD also, he runs the Office of Appointed Counsel. So he parcels out the cases. And if you're appointed, you can get an investigator. You don't even go to the judge. You say, Drew, I need an investigator. This is how much I need. He'll say, well, yes or no. I'm going to give you less money, but if you need more, come back. I need an expert. I need a blood spatter expert. I need, you know, some other expert. And usually he's pretty good. Federal court on the CJA panel, it's a little more difficult, but still you can get experts. Now, and I don't know how many people know this, there's if you're retained, and you have a retained case, and let's say you're not paid that much money. You have a case, you're going to go to trial, you're paid $10,000, $15,000, $20,000, which, you know, for a week-long trial is really not that much money. I mean, it's nice to get the chunk of money, but really, for a week-long trial, you know, with preparation and everything, it's not that much money. And if you need an investigator, client may be tapped out, and I hope your retainer agreements say that investigators are the client's costs. Sometimes they don't have money, and sometimes an investigator or an expert can make or break your case. So there's something called a Wittis motion. How many people are familiar? Okay. Here's what it is. Dennis Wittis is a lawyer in Reno. He had a case where he was retained, but he needed an expert or investigator, and his client couldn't afford it. So he filed this motion with the court saying, hey, it's not fair. My client can't afford this. If he were appointed, he would be entitled to this. It's a violation of due process. He should get money from the court, and he did. So now what you need to do is file what's called a Wittis motion. If anyone needs it, call me. I'll email it to you. I use it all the time. Now, if you're getting paid $250,000, the court's not going to grant it. But if you, I mean, I've had cases like big, nasty sexual assault cases where I got paid pretty well, and I still got the court to grant it. Right now I have an attempt murder case where I'm in the process of doing it, and I'll get an investigator. But it's really important that you get these investigators, or especially like in a sexual assault case, it seems like many times the quote-unquote victim is not pure as the driven snow. I had a case, it was a doctor that was accused of sexually assaulting this woman 3 times. She kept coming back. Now, I mean, what's wrong with this picture? You know, not once, not twice, 3 times. So we hired an investigator. He had some money, thankfully. And she was from Hawaii, and we didn't send him, but, you know, we did some investigation. It turns out she had made unfounded allegations against several people there. And, you know, once they file sexual assault, there's the special victims unit, and for the most part, they're savages. I mean, I have knocked heads with these people. Luckily, this particular case, I had one of the few reasonable people. Of course, he's not on the unit anymore. And the day before we were going to prelim, and I sent him everything. Now, you don't have a duty at that time, but if you have something and you have a reasonable prosecutor, send it to him. It's like, you're going to disclose it anyway. It's like, look, just to let you know who your victim is, and just to let you know, I'm going to have her on the stand for a day and a half. And when I get through with her, you're going to be able to wring her out like a dish towel. So anyway, day before prelim, he calls me, he goes, Mace, I'm dismissing. Now, had we not done that investigation, that case wouldn't have been dismissed. So it's really, really important. So think about who you can use as an expert. Blood spatter expert, self-defense expert. I've used a self-defense expert that have helped. Also, sometimes you hire an expert. They don't help. So in that case, what you need to do, hire the expert, have him look at the facts, and if his opinion's not going to help you, don't have him or her write a report, because then it's not discoverable. I had a case with the DNA issue about was it the testing done right, you know, and it was compromised and this and that and everything else, and the state was going to retest, and we hired our own DNA expert who watched. And the state's expert, well, you know, this was your client, but this stuff, you know, we're not sure. And our expert said, not only did they do it right, if I were the one doing it, the ones they said were inconclusive, I said would have come back to your client. So obviously didn't have that person write a report. But I can't stress enough how important experts are.
Would you have to turn over the report if your expert isn't going to testify on it?
Absolutely. It's a report. You know, it's discoverable. But if your expert isn't going to testify, don't have him make a report, because have him talk to you. It's like a polygraph. Yeah, we all know polygraphs aren't admissible. But if it's coming back and it's favorable, you're going to find some way to get it to the DA or file it in the court for some reason, even though it's not admissible. And if it's not admissible, I don't know if you have sex cases that plead, they always make them do polygraphs. It drives me nuts. And also abuse and neglect. I don't know if anyone does any abuse and neglect. It's like Star Chamber down there. I had a case that went on for a year, 5 different trial dates. The judge does not substantiate the claim. So, you know, there's not enough evidence. And it's a preponderance of the evidence standard, not beyond a reasonable doubt. Client gets to see the kid again, and it's a nasty custody battle, which this is a whole offshoot. So after all said and done, and I mean, it was nasty. The DA was snarling at me, and I had co-counsel, and right after this is done, okay, we're feeling great. I get a letter from DFS saying, oh, after reviewing the case, notwithstanding what the judge has done, we are substantiating the findings. I mean, I went absolutely ballistic, but read the law. They can do this. So then there's a procedure. You can appeal. But guess who you appeal to? People from DFS. Great. So anyway, but the process takes forever. I've appealed to the DFS, and this has taken, it's almost a year now. But once they deny it, then you go to a quote-unquote fair hearing officer, and this is a neutral party. With abuse and neglect, it's a lower standard, and it's like, oh, these kids abused and neglected. It's a civil proceeding. The problem is that if you're in abuse and neglect court, lurking is the criminal proceeding. And because it's a civil proceeding, the state can call your client. So there's a couple of ways you can go. I mean, if you know it's going to be bad and you're going to lose, you don't let your client take the stand, and you basically plead no contest. So they don't take your testimony, but then you lose, but you preserved it for the criminal case. Or when you go up there, you take the fifth. In this particular case, all these allegations of what my client did took place in Montana. So there was no possibility of criminal charges down here, so he testified. If it had happened down here, I wouldn't have let him testify, and we may not have won. So, anyway, where were we? Grand jury indictment. So once state system, you go right up to district court after your grand jury indictment. Well, let me back up. So we've gone to the justice court. Now you've got the municipal courts. In Las Vegas Municipal Court, you have the initial arraignment. And it's interesting because in justice court, you go in there first day, you plead not guilty on behalf of your trial. They hand you the discovery. You set it for trial. Municipal court, same courthouse, same charge, DUI. I mean, use the city statute, not state statute. You go in there, appear for your client, plead not guilty. They give you a copy of the complaint. No discovery. Takes a week to get the discovery. And you set it not for trial, you set it for a pretrial hearing. And then you meet with the prosecutor, and they make you an offer that you don't take. And usually you set it for another pretrial hearing. Now, usually you don't get anything done at the pretrial hearings, but I believe, as most defense lawyers believe, that they don't try you, they can't convict you. You know, sometimes witnesses leave or whatever. I mean, if they offer you what you want, you take it. But for the most part, it's continue, continue, continue. And after a while, the DA or the city attorney of the court, all right, enough. We're either dealing this or trying it. But, you know, each case is different. North Las Vegas, Muni Court, same thing. But interestingly enough, on those pretrials, usually bring the client because they get resolved. Domestic violence, it's a lot easier to get it resolved in North Las Vegas when it's not. It doesn't end up as a domestic violence conviction, and that's the important thing because, as you folks probably know, you have to do 26 weeks domestic violence counseling. You have to do 2 days, unlike a DUI where you can waive the 2 days and you can do community service, or usually you can just work it out as credit for time served. You cannot do that on a domestic violence. And it's a progressive crime like DUI. For instance, you got to do 2 days jail first time and 13 weeks. Second time you have to do 10 days jail, and you have to do it at least 10 days jail, and you got to do the 26 hours first time, a whole year second time. Higher fine third time, felony 1 to 5. Nevada State Prison, no probation. And the other thing, if you get convicted of a domestic violence under federal law, the Lautenberg Amendment, you cannot own a firearm. That's a big deal to a lot of people. Now, I've had cases where, and it was weird, it was in North Las Vegas, it got sealed, but the way it was sealed, it still would have affected his gun rights, so we had to unseal it, open it up, modify it, change the language, and then he got his gun rights back. But easiest thing is, like, don't plead in domestic violence if you absolutely don't have to. In justice court, there is a domestic violence court. It's Judge Melanie Tobiasen. She's good. She was a DA. She was a hard-charging DA. But she's been around the block. She knows what a court case is worth. And you deal with a unit all the time that knows what's going on, so they are a little flexible. I had a case with client was a pain in the butt. I mean, client's got more money than God. I don't know if you ever saw Romeo and Michelle's Big Adventure where the nerdy guy comes in on the helicopter. That was my client. Okay, real nerdy guy, he comes in, he's impregnated all these women, and, he takes care of all the kids because he's got all these monies, and, he's duking it out with this one woman, and yeah, he's had sex with her, and yeah, it's his kid, and all she wants is this educational trust for the kid of $692,000. My guy didn't want to do that, and it was after this, lo and behold, there's a domestic violence charge while they're going through paternity, and through her lawyer, well, if you just set up this trust, it'll go away. I didn't like that at all. Luckily, the DA is someone that's decent, and, I talked to him. I couldn't get in touch with him. I said, look, here's the deal. They're both whack jobs. I'm telling you right now, and I don't know who's worse. But I don't think this happened. I think they were drinking. If you notice in the police report, she went to the hospital, and she's pissed off because the hospital said there's no marks. So why don't we have the guy go to anger management? Well, I looked at this. I talked to her, anger management, what I like them to do is do the 1 day anger management. You can do it online. It's great. Well, no, that's not good enough. Well, how about the 13-week anger management? Usually you have to do it, face to face, which is frankly a pain in the butt. I said, well, do you have any problem doing it online? He didn't have a problem. Judge will go along with it. The good thing is, even though it's 13 weeks, 13 sessions, you can do them one after another. He finished in 2 weeks. And then the case got dismissed. That's a great resolution. And then if the case gets dismissed, you can seal the record. Sealing the record's wonderful. I mean, we have so many clients that wants their record sealed. And it's easy. Well, it's a pain in the butt, but it's easy. They just changed the statute. Essentially what you need to do is you got to get their scope, their criminal record, and now they changed it. You have to get their actual fingerprint card before you get a copy. Now they need their actual card. It's a civil petition, and you file it, and usually it takes between 3 and 6 months. Unfortunately, they just changed the procedure, so if it's in more than one court, you have to do a separate thing for each court, so it's more difficult. But it seals the record, and once it's done, no one can look. And under Nevada law, if someone asks them, have you ever been arrested or charged with a crime, you can truthfully say no. It's a legal fiction, but that's that. So what we do is whenever we get a case dismissed, we always recommend seal your record. Now, in federal court, you cannot seal a federal case. You can't seal a federal felony. You can't even seal a federal misdemeanor. So if it's federal, you're SOL. So we did sealing the record. Where are we? I actually do have a script. Oh, one thing about the outlying departments, you have a case up in Pahrump or in the Cow counties. For the most part, the good thing is you can do fax arraignments. So if you have a case up in Pahrump, you can just write a letter, I'm representing so-and-so, and, I'm giving you my appearance. Now, Pahrump, what they do, even in felonies, they have a pretrial hearing where they want you there to meet with the prosecutor. And I have a goofy case that's really a civil case. It was the weirdest thing because this guy was a retired lawyer and a retired doctor. He's 80 years old, and my client worked for him, and she was having problems with her ex-husband. It's like a soap opera, but anyway, she worked for him, and he paid her credit card, and she's doing all this work. Then, according to her, he wanted to have a physical relationship, and she didn't think that was a good idea since he was 80 and she was 30. Then after that, all of a sudden, told the police she was ripping him off. Oh, by the way, she's a correctional guard at the Southern Nevada Correctional Center, the federal prison. So she gets arrested, and they haven't charged her for about 1.5 years. He sues her civilly, and I'm representing her criminally, and say, okay, I'll do this. He also sues the temporary agency. Really, the temporary agency, he lets out. And it's set for, I don't know how many people do civil, but I assume a bunch of you do. The 16.1 hearing, and I'm communicating by email. And the other lawyer for the the temporary agency, they're setting up the 16.1. Well, the guy didn't have an office. He's sooner pro per, so we have to meet at the Pahrump Library at 10 a.m. So he goes up there, I go up there, and, he's got these documents, gives them to him. I said, well, do you have anything for me? He goes, you weren't invited. What? Oh, you weren't invited. Steam's coming out of my ears. I went all the way to Pahrump. I'm like, fine. So anyway, I go, back to my office. Of course, I'm steaming. I want to file something. I'm like, well, wait a minute. You're supposed to do this in 30 days. I actually read the rules, which I hate doing, and going through the thing, and it's like you only have enough time to continue. It's been over a year. So what I'm trying to do is tell the criminal, say, look, he sued us civilly. It's really a civil matter. And that's what it is. It's a civil matter. Don't you want to dismiss this? Because we're past 270 days, and I'm going to get that dismissed. But obviously the criminal matter is the worst thing. But Pahrump is kind of like the Wild West. A lot of those cow counties are Wild West. And if you do cases somewhere, like in Reno, I always get local counsel. And it's just easier. Lots of times in federal court, I'll be local counsel to other people. And in local counsel, it just depends. Now, according to local rules, you're supposed to be there every time you're in court. Some judges will make you, some won't. But you have to be really careful. I mean, oh, look, we'll just pay you $1,000 for the whole case. It's like, no, that's not going to work. What I like to do, and I talk about retainers, flat fees, this and that, but for that kind of stuff, either you need to take a flat fee that's really going to cover you, or you do a hybrid. I like to do hybrids in those cases. Okay, put $5,000 in my trust account. I'll bill you at X amount of dollars. $2,500 is non-refundable. And the reason why I like doing that is $2,500 goes right in general, no matter what. And then you just bill against it. If you have to go a lot, you take it out of trust. If you don't, you don't. That seems to work the best. Federal court, you never know. I mean, for criminal cases, I love flat fee. Misdemeanors, I charge a flat fee for the most part. I'll let clients go hourly, but I'll tell them, look, I'm really thorough. My hourly rate's high. If I charge you hourly, every time I do something, every time you call, we're going to bill you. I don't think it's in your best interest. Usually about 1 or 2 a year will want to go hourly. I warn them. I say, okay, this is what I would charge you if it's a flat fee. Okay? I want that much in my trust account. And it's always more money. I had this juvenile case where I want to charge them $5,000 flat. No, that's an awful lot of money. It's an arson case. We don't think they're going to file. It's like you talk to the investigator. They're going to file. No. Okay, fine. Of course they file. And they broke a window, so we're getting ready for trial. I'm geared up, ready to go. They continue it. Okay. Here's my bill. I got ready for trial. Do it again. Same thing. Continued it. Send them again. Finally, it's like, would you cap this? All right. I capped it at $12,000. I warned them. I would have been happy with my $5,000 up front, but that's the thing. You got to give them a choice. But I hate billing, so flat fee is good for me. Now, when you go to a district court case, if you have felonies, you got to be careful. I mean, if you have what I call garden variety low-level felonies, possession of controlled substance, even possession with intent to sell, if you know it's going to deal, you can give them, flat fee through completion. If it's a case that, robbery, burglary, that may end up going to trial, what I do is I always break up my case. It's like X amount of dollars through preliminary hearing, or so much would go to trial, which is usually at least 3 times what it is through prelim. Prelim's easy. They'll put on 1 witness, maybe 2. You don't have to deal with picking a jury and everything. And I learned my lesson a long time ago. I used to say, so much through negotiations and so much through trial. But it's like, oh, we're negotiating. Oh, we decided to go to trial. We don't have any more money. So it's like, well, I learned my lesson. Okay, it's so much through prelim. You want to go to trial? Fine. I need the money. And if you're practicing, you know, money's a big issue. And you learn, I mean, they're criminal clients, let's face it. You know, the ones I love are the fraud guys. They're the best. Have a guy coming in for bad checks. Well, can I pay you by check? And I looked at him. Said, if you can find a lawyer that'll take a check, don't hire him because he's too stupid. You know, really? I mean, come on. And then there's these, the ones I love. Oh, your fee's no problem. Yeah, it's no problem because they're not going to pay you. So whenever they say that, it's like, well, there'll be no problem paying my full fee up front. You know, I don't know. Over the years, you know, and I'll take payments and everything, but since credit cards, I'm a lot happier. And what I'll do is like, okay, I will take payments, but here's the deal. I want half up front, and then I want a credit card I can hit every month. And if it's declined, I'm withdrawing. And actually, and I don't know, my staff found it, but there's this ACH stuff. You can actually do it with checks, and you can take it out automatically, because if you don't do it that way, you're going to get screwed. Of course, there is the rare client that only wants to pay cash. Doesn't happen as much as it used to, and I will do that now and then, but it's, you know, watch out. Yes.
No,
interrupt. Depends on the judge. I mean, if you go through prelim and then you get up to district court, at that time you're going to get out. For the most part, if you're in a trial, they will not let you out. Federal court, forget it. Unless you can do a limited retainer, like this retainer is only good through the initial appearance. It's only good through the detention hearing. Only good through the motion period's a little tough, but most federal judges will not let you out. So you got to roll the dice. And I mean, for federal cases, they're expensive. What I usually do in federal cases, it'll be, you know, so much through the detention hearing, and then put them on hourly. But like you say, you get stuck.
I just moved to New York, and there, you know, it's easier to get out of federal cases, harder to get out of state cases.
It's easier to get out of state cases, but depends where you are. But no, it's hard to get out of federal cases. Unless you do, I mean, it's my understanding there's some law firms that do quote-unquote unbundled, which I mean, if it's not unethical, it's awfully close. You know, they'll go to a divorce hearing, one hearing, that's it. But, you know, in criminal stuff, I mean, I've gone to detention hearings that have taken 2 days, and that's it. I think that's fine. But, you know, you have to be really careful, because when people come to me and say, all I want you to do is file a motion to quash the warrant, I won't do it. It's like, look, I'll be happy to handle your case. I'll file the motion to quash the warrant. You know, if it's a misdemeanor, I'll handle the case. Or if it's a felony, I'll file the motion to quash the warrant. I'll handle it through preliminary hearing. But I'm not going to do that for that reason, because they're not going to let you out. And I think you look like an idiot. And, you know, I try not to look like an idiot unless I'm doing it on purpose, which sometimes is good for your clients. So, where are we now? Does anyone have an area they want to talk about? You know, no? Just going to let me rattle on? Okay.
For people who don't do criminal law, how do we get started?
Oh, good question. What kind of law do you do?
Bankruptcy
And contracts? Okay, bankruptcy. You do financial stuff all the time? Okay. You want fraud clients. Because you're familiar. I would talk to all your bankruptcy people, say, hey, you know, anyone has fraud, you talk to your business people. But as far as building up a practice, I love appointed work. When I started practicing in California, I didn't know anyone. And I nosed around, and in those days, they had what I call queen for a day. If you qualified for appointed work, there were some courts, and I used to go, and I didn't realize how bad it was, but I used to go to Compton. And they have a thing, they would have for the morning, they would have one lawyer, and every time there was a conflict, they'd have that lawyer. So you'd go in there and you'd get 10, 12 cases. If you want cases, the one that's, and I'll go through the progression, but they always want people to do post-conviction relief. Because it's miserable. But they want people to do it. They pay you hourly. I think it's, does anyone do it? I think it's $100 an hour. $100 an hour on state post-conviction relief. You can find it. They always want people to do it. Drew Christensen's the guy. You can call me for his number. He's the office appointed counsel. I would do that. The other thing is, talk to other lawyers, because there's like me, for instance. I charge a lot of money, or at least I try to. And, some people will say, I can't afford you. What I usually do is I'll talk to other lawyers. Okay, I know this lawyer is going to charge this much. Say, well, how much money do you have? Oh, $500. It's like, talk to the public defender or call the Nevada State Bar. Also, Nevada State Bar Lawyer Referral Service. Talk to them. They also have a low-fee panel, and you're going to get cases that way. But I like appointed work. There's post-conviction work. There's appeals, and then, eventually there's like the more serious stuff, the murder panel and everything. But talk to other lawyers, because there's lots of stuff that people won't take. There's some lawyers that don't want to do misdemeanors. I'll do them, but a lot of lawyers just don't want to do them. There's some people just don't want to do like cases in Henderson, because Henderson Muni can be a pain in the butt. I know a lot of lawyers just don't want to do it. They're fine cases. They just don't want to do it. Some people don't want to go to Pahrump. If you don't mind driving, it's easy to get appointed on cases in Pahrump, like real cases. I want my associate to do some work in Pahrump. We've just been so busy we haven't gone up there. But, go up there, introduce yourself. It's like small town. Talk to the DA, Brian Coonsey. He's really nice. And just introduce yourself, and you'll get cases. After the first one, you work it to death, you do a good job, you'll get appointed on other ones, because they need people to do it. Talk to the PDs, talk to the alternate public defenders. Just talk to the judges. Say, hey, look, I'm new, I'm getting into criminal law, I'll do whatever it takes. Go watch trials. Talk to other lawyers, like volunteer, because, it's like that out of reciprocity. It's like, well, this guy's helping me out. I want to throw him a bone or something like that. That's what I would do. That's what I did. And, you will find work. And just get it out there. Oh, yeah, I'm doing this. But, if you're doing bankruptcy, I would talk to all the businessmen and everything. Like, one thing that actually kind of came to me lately, I've done all kinds of stuff, and I get friends that are divorce lawyers. It seems lately every one of them has an offshoot that there's a domestic violence, because if there's custody issues, that if someone gets convicted of domestic violence, by law they can't have primary custody. So a lot of this comes up, and it's BS, but it's like used as a wedge. The other thing they do, if there's custody, there's sexual assault allegations, which is a much bigger deal, but it happens, and the DAs know it happens. So that's that kind of stuff. Were you raising your hand or scratching? Okay, all right. Just want to make sure. I am paying attention, contrary to popular belief. All right, what else? Okay, let me talk about the federal system just a little different. Well, actually, before I get there, the way it goes in the state is you have justice court, you have a preliminary hearing, you lose that, you go to trial. You win, you're done. Usually you don't. You lose. You do direct appeal. And like most of us, you lose there. Okay, so where do you go from there? If you have a federal constitutional issue, you file a petition of certiorari to the U.S. Supreme Court. They only grant one in about 7,000, but that's where you go. Usually that doesn't happen. I was lucky. I didn't know what I was doing, and they granted it. But what usually happens if that time it's another somebody did something wrong, your constitutional rights were violated. Usually it's ineffective assistance of counsel. You go back, you file what's called a post-conviction relief petition. You go back to the district court judge and you file it, oh, this lawyer was ineffective, because on direct appeal you cannot bring that up. So you can file that the trial counsel was ineffective, the appellate counsel was ineffective. And let's say you lose, which happens all the time. And there's a whole issue whether or not someone even has the right to appointed counsel. Most judges will appoint you. So that's another thing. Talk to the judges and say, hey, I want to do post-conviction relief, so if there's anything you want to appoint me, I'm happy to take it. And on those, you generally get an evidentiary hearing. You put the lawyer on the stand. It's pretty funny because the DA ends up defending the lawyer. And you get an evidentiary hearing. You can usually get an investigator appointed. You lose there. Then you can appeal that to the Nevada Supreme Court. And if you lose there, then you move to the federal system. If you're appointed, you do what's called a writ of habeas corpus, which is a 2255 petition. They're federal practitioners because, all right, 2255 is when you're appointed. If you're retained, it's a 2254 petition. Same things, just whether you're appointed, whether you're retained, and then essentially the same thing. You've been, your constitutional rights have been violated because something happened. I had an interesting case is that this is a case where the district court, the now district court judge actually choked my client on the stand. I went absolutely ballistic. We appealed. I remember when he actually came up and argued the appeal, which I thought was pretty stupid. And I think it was Judge Rose. It's like, well, Mr. DA, why did you do this? This makes for a messy record. We don't like messy records. And he had a half an hour. They went over about 20 minutes. They said, well, we did go longer. You can have. And I remember I started my argument. Well, Mr. X is no stranger to prosecutorial misconduct. So he didn't really like that. But now we get along. Time wounds all heals or heals all wounds, whatever. But so after that, and one of the things I filed early was that there was another case in addition to the sexual assault and everything. They sent an undercover agent in to talk to him about this solicitation to commit murder. Now, there's a case called Messiah, and I mean, it's frankly, the ruling's great, but I can't believe they ever follow it, that says if someone's represented by counsel and you send an undercover cop in, you're supposed to read the guy his rights before you question him. I mean, it makes absolutely no sense. But hey, it was the law. I raised it, denied. And he lost on direct appeal. We lost because I did it on direct appeal. They did post-conviction relief. They lost. They did the appeal. They lost. The federal public defender took over. They questioned me, like, what'd you do? And there's two ways the trial lawyers do it. One, they'll fall on their swords, like, oh, I screwed up. Another one is like, I did everything I could. And with me, it just depends. If the guy's a jerk, it's like, up yours. But I mean, if the guy's not a bad guy, I'll do what I can to help him. It's like, look, I think I did a good job with this. Maybe I didn't do investigation. They'll ask questions. Well, did you talk to this one? It's like, it was 10 years ago. I don't know. If I can remember, I'll tell you, but I don't know. I mean, who remembers that stuff? Maybe now with computers because you type everything, but I don't know. But anyway, they lost in the district court. They went up to the Ninth Circuit, and they reversed. Now, usually it's on ineffective assistance of counsel, but it wasn't for anything I did. Actually, I preserved the record on this Messiah thing. Now, this is after 10 years. They're going to come back. I'm hopeful they'll deal with the case so the guy can get out. Anyway, that's the convoluted. And in federal court, you short circuit it because you go district court, Ninth Circuit appeal. You come back to the writ of habeas corpus, then you go back up to Ninth Circuit on that. And then if you lose there, you go to the U.S. Supreme Court. Did some? Aha. You have to speak up. My hearing's terrible. Padilla issue?
Immigration.
Okay.
Immigration, when they don't have status, and so then they get canvassed about, do you understand what you're entering into, how this can affect your immigration status? Do you have any recommendations on that?
Well, it's funny you should bring that up, because I had an issue come in today. There's the Padilla case, which is like the leading case, and there's another one starts with a CH, and I forget what it is. But the Padilla case basically says that, you have to be informed about those. It used to be it's a collateral consequence, but now it's absolutely you need to be informed. The problem, some of them, there's a time frame, but there's an issue. But I think you absolutely need to be informed. Now, sometimes, depending on what it is, I have actually, the guy's coming in, what happened was he pled, it was a forgery case, which is a wobbler. Could be a felony, could be a gross misdemeanor. He ends up pleading to attempt forgery, the gross misdemeanor. Hey, sounds great. He does, you practice immigration law, I would imagine? Yes, okay. He's sentenced to probation, but as part of probation, it's 9 months in the Clark County Detention Center, and he has 2 years probation. Now, my understanding, and correct me if I'm wrong, if you're not a citizen, you could be eligible for deportation, or maybe it's automatic, let me know, if you're in custody for a year, or if you're on probation for a year or more. So lots of times when you do a deal, you want to do 364 days, because that won't trigger it. However, if it's forgery, it's a crime involving moral turpitude, so that triggers it. It's a crime of moral turpitude, or if it's a crime of violence, right? Or it's a drug crime, or both. Okay, so anyway, what needs to be done in this case is need to go back and kind of massage the facts and turn it into something else that's not a crime of moral turpitude. So what I want to do is go back, call it something else. What I want to do, I don't know if I can, is go back, call it another gross misdemeanor, which would be my favorite gross misdemeanor is conspiracy to commit a crime. What is that? No one knows, but it's not a crime involving moral turpitude, I can tell you that. And I want to do credit for time served. No probation. Not 365 days. So if I go back and do that, that wipes out his immigration problem. Can I do it? I don't know. It's 2007. That's past the 1 year, but there's, God, I wish I could remember the case. Starts with a CH. It's in Kurzaban that kind of lets you slink around it. But best case basis, I can get the DA to agree, which I may or may not. Please speak up.
I said, so if you have that immigration issue, are you sending them to an immigration attorney?
Well, actually, she's asking me if I have that issue, am I sending an immigration attorney? Actually, the immigration attorney is sending it to me because I have to go to criminal court to do this. She has him on the immigration issue, but she doesn't really deal with the criminal court, and I do.
Yeah, but I guess my question is, if you're in the arraignment and you're in the plea deal, if you're...
Oh no, would I communicate with an immigration attorney? Absolutely. I mean, a little knowledge is a dangerous thing, so I know enough that I can't plead him to forgery or drugs, and I also know that, one DUI is fine, but a third time is no good, and a felony DUI is going to trigger things. So, I know enough that I would talk to someone, but, this is kind of going the back way. All right. Oh, okay. In state or federal?
State.
Okay. All right. Okay. State case. Normal state case. Say it's drug case. Okay. You have a drug case. People are being investigated. It's usually co-defendants. So you've got different police, maybe undercover agents investigating people. You get all these police reports. Okay. Now, usually in federal, what will happen is you'll have these undercover agents, and they never want to give them up. They never want to let you know, and you want to know who they are because it's important. Because if they're undercover agents, either they've turned them because they were bad people, and it's like, you don't what do they say? You don't have priests and rabbis and saints if you want to find lowlifes. You need their other lowlifes. And, once you get them up there, I mean, it's like they're great because you can impeach them, and it's a lot of fun. But anyway, what you need is, you need to file discovery motions. You want to know who these people are, and they will fight you tooth and nail. And here's what they do. They will say, oh, we're not going to use them. They're not a precipient witness. And, you have to show the court, now wait a minute, this person was part of this transaction. They're absolutely, positively a precipient witness in this. So the only way that they're not a precipient witness is they have to dismiss this count. So you go back and forth. Depends on the judge. Usually they'll give it to you, or they need to dismiss the count. Now, many times, your client knows who it is. So that really helps. But whether your client knows who it is or not, they have a responsibility and an obligation to tell you who it is. So you always want to ask for that. And it's Brady material. Brady is exculpatory. If they don't give it to you, you can get the case dismissed. So that's one thing. That's a place where you need an investigator. So once again, if you have a client with money, get an investigator. If you don't have any money, now the thing is that it used to be you couldn't get an investigator appointed at the justice court level on a retained case. I'm not exactly sure how it is. I've actually done it. I don't know if you're really supposed to do it, because before you're supposed to waive up and then get it appointed and then come back down. But right. Yeah, so you can do it, but it's really, really important to get an investigator. And then, you may need a drug person because of the drugs and everything, but that's what I always do, because I think it's, really important. Someone say something? Oh, hi. I feel like I'm going through a drive-through. Can you talk directly into the mic?
Can you hear me now?
Yes.
Okay, I was holding. Okay. Do you put on pop-up witnesses? That would be like the mother of the murder defendant that appears a week before trial, claiming that her son was home watching television on the night of the murder.
Well, here's the thing. Obviously, you have an obligation not to put on perjured testimony. And this just happened to me. When I meet, serious, and serious charges and everything, and when I talk to them, it used to be when I was younger, I had to know, well, did you do it or not? I don't do that anymore. Here's how I do it. I give them wiggle room. I say, okay, here's the discovery. Why do you think they're charging you with this? Or why do you think they think you did this? So it gives them a little wiggle room. And then they tell me. Or maybe before that I say, I don't know what went on. You do. I wasn't there. Okay? And whatever you tell me, I'm going to believe you. But if you tell me A, B, and C now, and then later you tell me X, Y, and Z, one of them isn't true. And because I don't know which is true, I can't put you on the stand. So that's that. Now, if Mom comes in and says that, I'm sending my investigator out to see what the scoop is. And I'm talking to my guy saying, well, why didn't you tell me before? Then you got to make a judgment call. Do you really want to put her on? I have a murder case right now where, they're looking for this person, Shannon, and these three guys are looking for Shannon. And, Shannon owes me some money. And my guy said, yeah, well, I know this Shannon, but she didn't owe me money. And then a week later, I didn't know any Shannon. Oh, okay. And I was at this barbecue. Oh, okay, great. Who was at the barbecue? My neighbors and my mother. Oh, okay, well, where was it? It was at this place. Great. Send the investigator out. Mom doesn't live there anymore. Okay, have a number for your mother? No. This is a problem. Has she called? No. This is another problem. But I think you need to make a judgment call on that. And, is there willful blindness? Yes. But I mean, usually you can tell. And I think you need to tell them, say, look, if you want to get on the stand and do that, that's fine. But you're risking perjury. And you let them know. And, it's the client's call whether he takes the stand or not. That's his call. It's his call whether he pleads or not. So if the client absolutely, positively wants to take the stand, there's two things I think you have to do. You have to move to withdraw, but you can't tell the court why. Your Honor, and I need to withdraw. Why? I can't tell you. So obviously that telegraphs to the court why, but I think you have to do it. Then the other thing is, when the client testifies, why don't you tell me what you want to do? Now, technically, you're not supposed to do a narrative, but under the rules, you can't ask questions like that, so you have to do a narrative. So you're kind of between a rock and a hard place. Now, when it comes to the other witness, that's different. It's not your client. You can actually say, I don't know, and ask questions. Stephanie? Thanks. So, anyway, that's how I'd handle it. And it's like, you wouldn't believe this, but people lie to you every day. They all do. I mean, I'm at the point now, it's like, I expect them to lie to me. And if they don't, it's like manna from heaven. I expect them to lie to me. And it's like, well, I have this guy right now, statutory sexual seduction, okay? He allegedly had sex with this girl who was 15 years and 9 months when he was 30. If he had just waited 3 months, it would have been fine. But no, 15 years, 9 months. He's married to the older sister. 15-year-old, 9 months, she's really heavy. This guy, I mean, he's kind of a piece of work. Wife is working at the casino. He's home, playing video games. How can I say this politely? Pleasuring himself. And wiping himself off with his T-shirt and everything while she's in the room. Well, anyway, according to her, they have sex several different ways. She doesn't want to testify. I mean, there's no question that it is consensual. But, she's under 16. Does she have consent anyway? Well, there's this one prosecutor, Mary Kay. Has anyone dealt with Mary Kay? She's a true believer. She and I have knocked heads for over 20 years. And I mean, now it's fun. I mean, just when she sees me, it's like her neck goes like one. So it's great, because I get to, I just have to talk to her and she's already upset. So anyway, have this guy and charge him with 18 counts, 14 counts, statutory sexual seduction, which if he's done anything, that's what happened, and 4 counts of lewdness. Okay, we're in Henderson. We fight about bail, $150,000. I think it's pretty high. But that's what it is. They make the bail, which is kind of amazing, and he goes back to California. She calls me and she says, I'm filing all these other counts. What other counts? Attempt sexual assault. What? Yeah, she was under 16. And I'm like, are you kidding me? Really? Yeah, that's what I'm doing, and I'm putting it on calendar tomorrow. Oh, okay. Well, you better get your guy in. I'm like, I don't think so. He's in California. Well, I don't agree. He doesn't have to be there. I said, with all due respect, who died Major the Queen? I'm not bringing him in. Well, I'm going to ask for him to be remanded. I said, you can ask for whatever you want. So anyway, we go in there, and it's not the same judge. It's this visiting judge. And, and she says, and I want him remanded. And the judge looks at me and goes, why isn't he here? I said, Your Honor, she told me yesterday afternoon, I'm in contact with my guy. I talked to him earlier. Past this a week, I'll have him here. So, can't we deal this? Can't we deal this? She makes some offer. I said, it's going to take me a while to work on. Not a bad offer. 2 counts of 1 lewdness with a minor, or 2 counts attempt lewdness. So they're 2 to 20, but they're probationable. And I thought it was going to go in front of Judge Corey, which is probably a good place to be. the guy's 30 years old, never had a problem. The victim is not the one that's, pushing it. It's her mother, and, it happened because he's on Facebook. He's now engaged to someone else. He used the same ring. It's the circumstances are a little weird, be that as it may. So anyway, she said, I'm asking for all this extra bill. I'm like, are you nuts? I said, hey, I haven't seen the reports. I haven't seen the statements. All I have is from like a year and a half ago, because they went and talked to him in California. He hasn't been around. She's here. He's been in California for a year. And so we're going in there. I said, so when did you talk to her, do these? She goes, oh, I just talked to her for 10 minutes. Really? Yeah, I just talked to her. Did you talk to her about all this stuff? No, I didn't even talk to her about the facts. Oh, okay. So she goes in, she makes her pitch, and I said, Your Honor, she's pissed off that he's out. That's what this is about. There's nothing else that happened. She didn't even talk to her. She's just pissed off that he's out. That's all this is. He was out there, he's on electronic monitoring, he's done nothing wrong. There is no reason for this. And he said, you're right. I said, well, Mary, I'm pulling this deal. It's like, okay, fine. So, I'm talking to him, I'm saying, look, there's 57 counts. I think it's BS. Well, that's not really the term I use, but you get the drift. But I said, I think it's absurd. But the problem is, you get convicted of one of these, you're looking at potential life imprisonment. So I think it's really in your best interest that we deal. I don't know, blah, blah, blah. Okay, fine. So anyway, I get a call from old Mary Kay. I said, so, what's up, Mary Kay? She goes, well, it's a good day for you and not such a good day for me. Why is that? Well, my team chief took a look at that, and he says that, yeah, I could easily make the statutory sexual seduction, but he thinks that the attempt sexual assault is going to be more problematic, and it may screw up the rest of my case. Oh, okay. So what's your offer? 2-count statutory sexual seduction. Oh, you're going to stand silent? Okay. Right to argue. And, I talked to the client. And it's like, look, you need to take this. But, no buts. And I said he's going to be able to do an Alford plea. I don't know if you folks know what an Alford plea is. Alford plea is the plea when I can't admit that I really did something wrong, even though I probably did, but I'm not going to admit it. So you don't admit any facts. Because on a regular plea, on such and such a day, I did this, and these are the elements. Did you do this? Yes, blah, 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 blah. And you got to do it for the plea to go forward. But an Alford plea, there's a decision, Alford versus North Carolina, which basically says, I'm not admitting any specific facts. However, I am entering this plea because I'm concerned that the state could prove this and have really, really harsher punishment. Okay, so that's what we're going to do. So then the client's back and forth, and he's got, his fiance, and she has like teenagers, so he's not living there. And he's got, I call them his handlers. He's got these, religious people. He's got religion now, and, he's pure as the driven snow, and they're trying to tell me what to do, and this doesn't go over very well with me. And when we're trying to keep him on the $150,000 bail, the guy comes up to me, are you going to ask for OR? That did it. I said, look, you want to hire some stupid kid that doesn't know what he's doing, that's going to listen to you, you go do it. But if you want me to handle it, I'm going to handle it my way. You're a CPA. I don't tell you how to cook the books. Don't tell me how to practice law. So anyway, we kept the guy out. We just entered his plea yesterday, and I'm, in front of the lower level arraignment, and the whole thing is registration. For statutory sexual seduction, it's not lifetime registration. It's only 10 years. So anyway, I know that Stephanie said we're not taking a break, but she lied because I need to use the restroom. So take about a 5-minute break. I'll come back. Stephanie, at this time, I'm going to need you to do the PowerPoint. Okay? Have any other questions, just ask me, and then we're going to roll through this because I've done this in an hour, I've done this in 2 hours, so I'm going to talk fast. Okay? right, before we get started, and I've done this presentation an hour, 2 hours. I'm going to roll through it in 20 minutes. But if you have any questions, ask. After it's finished, I'll get done by 5. You want to ask me questions, I'll stay. You want to email me, I got motions. Anything you want to do is fine with me. Okay? Let's see. Why isn't this working? Oh, it works. Okay. Anyway, I'm a musician. I play the piano. I play the harmonica. I recently played at a friend of mine's wedding. I play at these bar things. I'm a good musician. And when a trial is like a performance, it's like a play, it's like a musical performance. You know, you got to start strong and you got to end strong. And so that's how I look at doing a trial. And that's why I call this presentation, well, I called it, Using Theater in the Courtroom. So this is how I try a case and how I think you should try a case, because people of my generation have an attention span of about 18 minutes, which is a half-hour sitcom minus the ads. These days, about a minute maybe with MTV or 10 seconds with Instagram. So you got to grab them or they're done. So you can't bore them or they're gone. You'll never get your point across. Okay, set the stage. What does that mean? You got to interact with court personnel. These people don't know you from Adam. They don't know that, you represent these scumbags. So you're on equal footing in the beginning. So you got to make sure that the court personnel, they like you. You got to familiarize your client. You've been in there 20 times. Client hasn't. So you got to come in. This is where you're going to sit. If you can bring them in the day before, that's the witness stand, because they're going to be nervous, really nervous. Okay. I have a checklist. Okay, I want to do this, do that. Have my computer, have this. And I'm ADHD. I lose stuff. So I always need someone near me to make sure I don't forget stuff. Props. I love props. Don't have anyone smoke? Anyone have a lighter? No. Good. You have a lighter. You ought to be ashamed of yourself. Let me see the lighter. All right. Evidence. You want to get to evidence. And, when it comes to props, you don't have to be like super. I have this PowerPoint now, but do we have a marker for that? Where is she? Stephanie. So I want to show you some stuff later. But anyway, you need props. I had a case where it was a federal case and it had to do with blowing up some stuff and fires. And there was this one guy, he was a pyromaniac, so I was standing there going like this. Remember, he was doing that. I set off the fire alarm, but I made my point. But anyway, simple prop. You can just do this. I remember a long time ago I did a murder case, and this was like when, you had the old cell phones. They're like huge with the whole thing, and I was using that as a gun because I was nervous, and I was worried about negligent discharge, which I thought was a venereal disease, but that's another story. Anyway, questions. You want to ask questions. Jury instructions. Jury instructions are really, really important. They're boring, but if you have a question on the law, it has to come out with the jury instructions. There's always these stock instructions. They're there, but you really need to look for your own instructions. I had a murder case, and it was a robbery and a murder. And one of them was self-defense, and then they were fighting for the gun, and there was an accidental killing. And I found this instruction, and frankly, I've been looking for it since then, and I don't know where it is. But it was a Virginia pattern instruction, and it said, if there is an accidental killing, and it could be that it was intentional or it could be accidental, then you shall find the defendant not guilty. And we use that. And then, with self-defense, Nevada's a great self-defense case because on self-defense state, there's no duty to retreat. And if you make a prima facie case of self-defense, then the state has to prove the self-defense, that there's no self-defense beyond a reasonable doubt. So essentially they have to prove a negative, which is very difficult to do. I love self-defense cases. Rather do a self-defense case than a drug case than a sexual assault case, even though you got a dead guy. All right, set the scene. You got to capsulize it. One statement. A friend of mine, Gene Iredale, wants to do it in 6 words. I'm not that good. But you want to have one case. This is a case about theory of the case. There's the Sodi defense. Always good. Some other dude did it. We like that one. They got the wrong man. There are dopers, deadbeats, and dropouts. I like alliteration. Also, you want trilogies. I'll get into that later. See, the toady defense. This other dude did it much better than the Sodi defense. Primacy and recency. Very important. People remember what you tell them right away. They remember what they tell them at the end. So you got to hit them in the beginning. You know, I had this self-defense case and talk about repetition, repetition, repetition. What would you do if he was shooting at you? There was no place to run, nowhere to hide, no one to help. What would you do? They'd shoot back. That's what I wanted. Self-defense case. See? There it is. I remember. Anyway, storytelling. Keep interest. You can't go in there and say, oh, well, you know, he might have done it, but it's reasonable doubt. I don't think he has it. You don't want that. You got to come up with a story. You got to develop a character. You use colorful language. Sneaky, sniveling snitches. I love going after snitches. You got to get the discovery. And you can go after them. And you, oh, well, you know, and you got paid. And like you were in there, right? And you know, you're looking at a 10-year sentence, right? And then you met with the government. You met with them all the time, right? And you only did 2 years. And, you know, you have his record. You show them. It's great. And they lie. You get to tell your client's story. Now, can you put your client on the stand? I mean, I go back and forth. If you have an articulate client, which granted is an oxymoron sometimes, but if you have an articulate client and he doesn't have a felony, I think you want to put him on the stand. You have a self-defense case, you have to put him on the stand unless you have a precipient witness. I once did have a self-defense case where my client had a little stutter, so I didn't put him on, but I had a witness that I could put on, and we won that case. It was good. And I always like to say, you know, truth never changes. Oh boy, I got a rattle. You know, you got to use quotes. There's this one prosecutor, he's retired, always used to use quotes from the Bible, which really pissed me off because I didn't like him using a source I never read. So there's this great reference, Macmillan's quotes from the Bible. So I got that. It's like, you know, seek the truth, speak the truth, truth set you free. Whenever you have one where truth is at issue, I used to tell this story, and I'll tell it really fast now. In the olden days, someone was looking for truth. Where's truth? The hunter's looking. I'm looking for truth. Oh, it's over the valley. Oh, he goes to the valley. Where's truth? Oh, it's over the hill. He looks for truth. It's over there. Oh, truth is over there. And he gets to this cabin. I'm looking for truth, and there's this old, wizened woman. And she's sitting there. I'm looking for the truth. I am the truth. Oh, I finally found the truth. That's wonderful. I'm going to tell everyone far and wide. She says, well, when you do that, would you tell them I was young and tell them I was beautiful? And that's the kind of truth they want you to believe. So anyway, you do that with the good cooperating witnesses because they're lying. You can do the burning witches that sometimes, you know, when the wind is right and consistent with the due process of the day, you can smell those burning witches. But don't do it in an arson case. Jury selection. This is tough. Federal court, you don't get it. You got to use self-disclosure. You know, you may not be a good juror for this case. I'm not a good juror in a robbery case because I got robbed once. Go through the whole thing about George Bush, the original George Bush. Remember, he hated broccoli. If broccoli was on trial, no good because he'd be prejudiced. I know broccoli's not going to be tried, but you get my point. You got to get the jury talking. You got to get open-ended questions. Why, where, this, everything else, this. You know, you can be fair, right? Yeah, that's not what you want. So you want to get them open, but closed-end questions. If you got someone that's, you know, is prejudiced, you want to nail them down. I call it the cause coffin. You know, if you can tell, oh, well, you know, there's not enough evidence, right, to right now because you haven't heard anything. Well, there's enough evidence that the prosecutor brought him here. I'm like, okay, we got to get rid of her. And I was going back and forth with the judge, and then it's like, well, you're a woman of strong opinions, right? You nod, they nod with you. Believe it or not, they do. It's really good. And if you believe something, you're going to stick to it, right? And it doesn't matter what I say. And it doesn't matter what DA says. It doesn't matter what the judge says, right? And you believe this. Challenge for cause. And so the judge tries to rehabilitate her. And I remember this one juror, and I've asked this question, and they never answer it the way I want. But I was so frustrated. I said, okay, Madam Juror, if you were on trial, and she, oh, by the way, she worked as a dispatcher at the DA's office, and her 4 brothers were cops. But she could be fair. And I said, if you were on trial on a charge like this, would you want 12 people with the same mindset as you as your jurors? You want like this? No. Challenge for cause. Got rid of her. I call it the cause coffin. All right. Where else? Preview what will come out in trial. There's going to be bad facts. Throw it in there in jury selection. As I said, got a murder case, there's a killing. That's a bad fact. Okay? Drugs. Got to know your audience. No lawyer words. There's really Terry McCarthy. I don't know if you know who he is, but he's an old-time law professor, great lawyer. He always talks. You talk to people like you're sitting in a bar. You know, you get lawyer words. He talks about people having a lobotomy. You go to law school, you don't know how to talk anymore. You know, you say, subsequently, they got out of the vehicle. No, it's later they got out of the car. That's what you want to say. Okay, I love quotes. Freedom's not a gift from God. You must fight for it every day. Be daring. You can read them. They're in your materials. Okay, I love trilogies. Trilogies people remember. Blood, Sweat, and Tears. Faith, Hope, and Charity. I came, I saw, I conquered. The good, bad, and the ugly. What else do I have up here? So they remember things in threes. Don't know why. They do. Okay. Repetition, repetition, repetition. Loop good answers. For instance, you know, you're talking to someone, it's like, oh, it's a self-defense case. And then the big guy came at him. Oh, so the big guy came at him from this angle. Yes. And the big guy was getting closer. Yes. And the big guy looked nasty. Yes. And the big guy was scary. Yes. So she gave you the big guy. So you want to ask your questions with the big guy because you have a self-defense case and you want to establish that they're scary. Or the look could kill, anything like that. When they give it to you, that's why you got to listen. That's why you can't follow the script. You use it. Okay, there's a book of Proverbs. I talked to you about that. Brainstorm with non-lawyers because we think a certain way and non-lawyers are on the jury. So that's what you want to talk. Presumed innocent. I've been doing this a long time. I used to keep that in the edge of my desk. Dog chain. Oh, this is a good one. I had this murder case. And in the murder case, they had a snitch. I had the anti-snitch, which I brought in from Colorado. But anyway, the testimony was that this guy, my client, tied up the decedent with a dog chain with one hand, and he held the gun in the opposite hand. Now, I knew that you don't hold the gun with a non-dominant hand, and I'm not a gun guy. And usually I hate NRA guys, don't want them, but I wanted the NRA guys on this because I knew they knew guns, and you don't hold a gun in your non-dominant hand. So what I did was I talked to my client, and I said, look, I'm going to borrow this, okay? And I said, I'm going to throw this pen, and you better catch it with your right hand, okay? So I'm talking like this. I whipped the pen at him. He caught it. I said, see, he's right-handed. You don't hold a gun in your non-dominant hand, and both the NRA guys went like this. I knew I had him. I won that trial. But, I mean, that's the kind of stuff you got to, more quotes. I like, for a self-defense case or a fight, Popeye, all I can stand and I can't stand no more. Logic doesn't win cases, emotion does. That's the way it is. You know, it's like the guy, well, you know, why did you buy that car? Oh, I went through Consumer Reports and I saw everything. Got great gas mileage. It turns well. You know, the guy's 65 years old. What is it? A cherry red Maserati. Right. But anyway, make them empathize. Feel what your client's feeling. Sometimes it's tough. You got to humanize them. You always have to humanize your client. What I like to do, and if it's a female client, you got to be careful. But what I like to do is I'm sitting there talking and I'm like, look, Mr. Smith here, you know, he's had a tough life. He grew up with a single parent. You know, they threw him out. His dad died, you know, but he made something of himself. He went to school. He got a GED, all that stuff, because the jury will say, well, if he's touching him or he's standing next to him, it's okay. You know, if I'm sitting there like this and I'm putting stuff between me, they're saying, oh, this guy, he's scary. Fear is a great motivator. If you can get them afraid of something, not your client, that's a good thing. Think of the actors, Anthony Hopkins, Glenn Close, John Turturro. They evoke all these emotions, and that's why they're good actors. Not Johnny Knoxville. You got to build your scene. You start it. You don't want to throw everything at them. You want to build it from the beginning. You're the architect. You know, that's why I like being a lawyer, because I'm the producer, I'm the director, and I'm the star. And you want to be the star when you're cross-examining. If your client's on the stand, you don't want to be. Now, federal court, They always want you at the lectern. Where's that stupid thing? The lectern. Okay. I don't like to be behind the lectern. So, they want you arm's length. I want here, I want there. Usually, in state court, they're fine. But I remember one time I was trying a case in front of Judge Pro, and it's like, Mr. Yampolsky, stand behind the lectern. Your Honor, it's bigger than I am. He goes, it's smarter than you too. That didn't stop you. What are you going to say to that? Anyway, humor. Use humor if you are funny. This is really important. Now, I don't tell jokes. I could tell jokes for days, Horse walked into a bar once with the long face. No, that's not what you want. But here's how you tell if you're funny. Tell 3 of your friends a joke. If they don't laugh, you're not funny. Don't tell a joke. Now, I remember I tried this case, and it had to do, my client supposedly robbed these people, and they saw him, but our defense was, he was in his car with his girlfriend messing around. So, we're fighting about discovery, and it's like, well, Your Honor, he said, well, I'll take a look at this in camera. The client's like, in camera? What's in camera? Judge said, well, I know it's in camera. DA knows it's in camera. And your lawyer knows what's in camera. He goes back there and, makes his ruling. So the client's on the stand, and he goes, well, we was getting down. Judge says, getting down? Yeah, getting down. What's getting down? Good. I know what's getting down. My girlfriend knows what's getting down. If you were there with your damn camera, you know what's getting down. I gotta tell the story. It's my favorite story. It actually happened. I was trying a rape case, and my guy was in the military. He's a black guy. It's important. And he supposedly, raped this 15-year-old babysitter in the double wide next door while Freckles the dog was there 5 times while the 5 kids slept. Okay? 5 times. What a guy. And this is my first case I ever tried, and I didn't realize you don't put someone on the prelim. Fools rush in where angels fear to tread. So I put the owner of the double wide next door to say that not only is Freckles a good watchdog, but he doesn't like black people, and he especially doesn't like my client. He chased him all the time. So then I recreated the scene. I had my investigator go out. I had the owner gone. I had my client knock on the door. We videotaped it. Freckles went wild. So I'm going to use this. And the DA, well, wait a minute. You can't use this. Judge says you lay the proper foundation. I'm going to let it in. So anyway, cross-examining the girl, going through the whole thing, and she's lying. I know she's lying. I'm hoping they know she's lying. So, he's had sex with her 5 times. You think she knows what his genitalia would look like. So I said, well, and these days I'd ask it differently. Was he circumcised or uncircumcised? She kind of looked at me. I said, well, did it look like an army helmet or an anteater? Jury went absolutely berserk. Court reporter put her head down. Judge put his head down, and I had my game face on. I needed an answer. And she said it looked like an army helmet, but it really looked like an anteater, which gave me 2 problems. How am I going to get this evidence in front of the jury, and would it stand up in court? So, after the cross-examination, the judge calls us up. He said, you boys need to work this out. And if everything you said about your client in opening, he goes, I'm inclined to give him probation. We worked it out. He got probation. So anyway, humor. If they're laughing with you, they're less likely to convict. Use the facts of your case. Demonstrate how ridiculous it is. Whatever you do, don't offend. Tough for me. I try not to swear. I've been pretty good today. The only time I swear if you quote one of the prosecutor's witnesses. That's pretty effective. And did you say he did this? I love it. Hit the high points. You want to leave something for the jury to get there. Use surprise. Whisper on occasion, because then they have to lean forward to listen to you. I'm pretty loud, but I do modulate. You don't want to talk in a monotone because they will tune out. Pause. Because if some of the jurors aren't paying attention, as they often will, and you pause, then they'll look at you. And pause before the big stuff. Use silence as a weapon. Let them fill in the blanks. 25% of all people suffer from mental illness. So Think of 3 of your best friends. And if they don't, guess what? To thine own self be true. Everyone has their own style. Jerry Spence has the hat, the buckskin jacket. Johnny Cochran, if it doesn't fit, you must have quit. I mean, me, I am what I am. You know, I'm a character. I bump into shit. The whole time. I've spilled water. I spill water almost every trial. Now I do it on purpose just to get it out of the way. But jurors like me. I make mistakes. Jurors try and help me out. It works for me. Wrap up. You got to start strong. You got to end strong. Primacy, recency. Very important. You know, it's like the old adage. You know, you got to tell them what you're going to tell them. You tell them what you told them. Go through the oath as a juror. You know, we're entitled to your decision. We're entitled to what you remember, not theirs. And you go through the whole thing in jury selection. And then I always talk about the crown never loses. Now, when I go through this thing, it's like, you know, the United States has the best system of justice in the entire world. And we got it from English common law. And in England, in London, England, there's the biggest, most majestic courthouse. It's called Old Bailey. And in front of Old Bailey, there's this huge rock. And emblazoned in this rock, it says, the crown never loses. And what that means is, as long as this case is tried fairly, it doesn't matter whether the defendant is convicted or acquitted, because as long as justice is done and this case is tried fairly, the crown never loses. By saying this, you let the jurors know it's okay to find the defendant not guilty. It's not going to hurt the DA. The DA is supposed to find justice right. As my friend Jerry Goldstein always says, there is no justice, just us. Anyway, you finish on a high point. Final words. I love Winston Churchill. I love him. In the immortal words of Winston Churchill, we shall fight from the landing grounds. We shall fight in the fields and in the streets. We shall fight in the hills, and we shall never surrender. Never give in, never give in, never, and nothing great or small, large or petty, never give in except to convictions of honor and good sense. And then you may end up not guilty. Thank you.